Hello all, welcome to the lecture. In today's lecture, we are going to talk about a very important topic, and the topic is the power to punish for contempt of court. Now, we have to understand this topic in detail. Now, recently, Supreme Court said that the power to punish for contempt of court cannot be taken away by the parliament. So what is important here is we have to understand firstly that what is this contempt of court all about. So it is emphasizing the rationale behind the contempt jurisdiction. What it is, that is to maintain the dignity of the institution of judicial forums. So we will be understanding over here that what is the power to punish for contempt of court. When we use this term contempt of court, what does it actually means? So what Supreme Court has said about this is, Supreme Court is very clear regarding this. What Supreme Court said is that the power to punish for contempt, which is mentioned in the article, we have to remember the article, that is the article 129 is a constitutional power, and if it is a constitutional power, it cannot be done away even by any law. So that is how important this power to punish for contempt is there. So article, we have to remember article 129. So the power to punish for contempt, what kind of power it is? It is a constitutional power. And this constitutional power is vested in the court. So can this power be taken away? This power cannot be abridged, or you can say taken away, even by any kind of legislative enactment. That is how it is. So it is a constitutional power. Article 142 clause 2 is very clear about it, and what it states is that subject to the provisions of any law made in this behalf by parliament, the Supreme Court, right, shall have all and every power to make any order on punishment of any contempt of court. So the power that is to punish for contempt under the article 129, it is a constitutional power. One more thing that we have to understand over here is that article 129, it lays down that Supreme Court shall be the court of record, and if it is court of record, it is going to have all the powers of such a court, including the power which includes the power to punish for contempt. So power to punish for contempt. So what we can see is, when we understand this article, it is very clear of the fact that Supreme Court as a court of record has the power that if any kind of contempt is there, it can punish the concerned individual or the concerned authority. Now this judgment that was passed, what was it all about? So this judgment came as the court held Rajiv Dahiya, who is the managing director of Rajasthan-based NGO Swaraj India Trust, and he was said to be guilty of contempt of court. So proceedings were initiated against him, and what was the case was that he failed to deposit a penalty of around 25 lakh rupees that was imposed on him, and that was in the year 2017. So this was all the case about. So he even wrote the president where he was seeking sanction to prosecute the judges, and there were a lot of petitions and writing letters and leaving accusations against the sitting and retired judges of the court. So this is how this case came to highlight, and thereby this judgment was passed by Supreme Court, a very important judgment indeed. So what was the court here was saying that the court actually gave Dhaya several opportunities, that he was given the opportunities that he has to deposit the fine, and there was a particular time period that was given to him. But thing was that there was this negligence from the side of Dhaya. So holding his conduct to be contemptuous, the bench said that after all these incidents, that there is actually no absolute license when appearing in prison. So uh, to indulge in making apersion as a tendency where they can scandalize the court in relation to judicial matters, and any kind of attempt, calculated attempts, motivated attempts, what all he was doing, he was trying to bring down the image of the judiciary, and that is something it is which is against the court, or you can say contempt of court has been conducted over here. So in highlight of this particular case, this statement related to contempt of court was given by the Supreme Court. Now, let us more understand about contempt of court. Now, when I say contempt of court, what do I understand by it? That this is the power of the court to protect its own majesty and respect. So this power is regulated, but it's not restricted in the Contempts of Court Act of 1971. One more thing, that we are talking about contempt of court and we are saying it to be a constitutional power. But we have to understand one thing over here is that this term, this expression contempt of court has not been defined by the Constitution anywhere. Very, very important. However, when we see Article 129 of the Constitution conferred on the Supreme Court the power to punish contempt of itself. And similarly, when you talk about, so we have to remember two articles over here, Article 129 and another article that is important related to it is 215. So in Article 215, it conferred a corresponding power on the High Courts also. Now, Parliament actually framed the Contempts of Court Act 1971, where the Act laid down procedures and punishment. So why is this act important and why we need to understand it further? See, this act actually divides contempt into two types. What are the two types? Civil and criminal contempt. So firstly, let us understand when I say civil, what does it actually means? When I am saying civil contempt, that means I am talking about the willful disobedience of an order of any court. That is, willfully there is a person and he has disobeyed the court. But when I am talking about criminal contempt, it includes any act or any publication which is scandalizing the court, the prejudices in any judicial proceedings, or interfere with the administration of justice in any other manner. So we are very clear that the Contempt of Court Act of 1971 laid down the procedures and punishment, and it divided the contempt into two kinds, that is the civil and the criminal contempt. So what we can understand is that civil contempt, it is that when we are talking about there is willfully something that somebody has done. Willful disobedience, that is there when any judgment of the court has been done and the person is not obeying by it. That will come under the category of civil contempt. But the criminal contempt, that is the conditions that is important. That suppose there is an individual or it is trying to obstruct the administration of justice. then it will involve the criminal contempt. Or if it's trying to interfere in the due course of any judicial proceeding, that will be part of the criminal contempt. Now, if you look at the section 5 of the Act, it provides that there is something called fair criticism, or you can say fair comment. Why we call something as fair when something is unbiased? We are giving a judgment based on our own experience or what we are observing in the society. That means the comment that is a fair comment on the merits of a finally decided case would not amount to contempt, and that is what the section 5 of the Act says. Very, very important. That it's very clear that the power of the court is there. The court is an important body, but with that there is open-ended terms. What if there is fair criticism? If really something that sort of is happening, we are living in a democracy and we as the citizens of the country have a right regarding that, right? So what is fair? It has to be done away with. But one more thing over here is that who is going to decide whether particular thing is fair or not? Who is the one? It is left to the interpretation of the judges. So this open-ended interpretation sometimes, even compromises the freedom of speech and expression under Article 19 as per the criticism related to the Act. That if everything is going to be, in such kind of monitoring process, it will be there. Then what about the freedom of speech and expression that a particular person has and that is conferred as a fundamental right to the citizens in the Indian Constitution? What about our right to speak? Now, it even violates the principle of natural justice. The judges may often be seen to be acting in their own cause, and this can even violate the principles of natural justice and adversely affect the public confidence they seek to preserve through the proceeding. So these are some of the issues that are related to the Act. So hope you have understood what is contempt of court. Thank you.